Thank you for that.
Fair? Okay.
Yeah, we can talk about it. I'm not sure if that was. Okay. Okay. Yeah, I'm like 2 rounds down stepping in. So I just don't know much as probably should.
All rise. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Chief Justice Justice Robert M. Davis presiding. All who have business before this court draw near, and you shall be heard. God bless the United States and this honorable court. Please be seated.
Good afternoon. I am Chief Justice Robert Davis, formerly Chief Judge Davis, senior judge status. To my right is current Chief Judge Bartley, and to my left will be the next Chief Judge, Allen. So you all are appearing before three Chief Judges. We're here in the matter of Dennis McDonough, Secretary of Veterans Affairs, petitioner against Walter Riley, respondent. Docket number 21, 2021. Are counsel prepared to proceed? Counsel for the petitioner?
Read Carrillo for the petitioner, Your Honor.
Seth Toops for the petitioner.
Mr. Creel, would you spell your last name?
C-A-R-R-I-L-L-O, Your Honor.
Thank you. And Toops?
T-O-U-P-S.
Thank you. Counsel?
Good afternoon, Chief Justice. Nancy Erickson with my co-counsel, Benjamin Lang, for the respondent.
Thank you. And I'm assuming that's L-A-N-G?
L-A-I-N-G, Your Honor.
Ah, thank you. Very good. Are both sides ready to proceed? Verbal response?
Yes,
Your Honor.
Thank you. Each team will have 30 minutes. That will be divided into 15 minutes per counsel. Will counsel for petitioner like to reserve any time for rebuttal?
Your Honor, we're reserving 2 minutes for rebuttal to be taken from my co-counsel's time.
2 minutes to be taken from Mr. Toops' time, is that correct? Okay, thank you. You may proceed.
May it please the court. My name is Reed Carrillo, and I, along with my co-counsel, Mr. Seth Toops, represent the petitioner in today's case, the Secretary of the Department of Veterans Affairs. I will be addressing the evidentiary sufficiency issue, while my co-counsel will address the class action superiority issue. We'd like to reserve 2 minutes for rebuttal to be taken from my co-counsel's time. Your Honors, the judgment of the United States Court of Appeals for the Federal Circuit should be reversed for 2 reasons. First, an assumption of parental responsibility is required to confer spina bifida benefits. And second, even if biology standing alone may confer those benefits, Mr. O'Reilly's evidence is insufficient. The government provides certain spina bifida benefits to the children of Agent Orange exposed Vietnam veterans. To be clear, Your Honors, Agent Orange was an herbicide used during the war which injured veterans and caused their children to be born with spina bifida, a birth defect. This is a case about a group of claimants seeking those benefits.
Counsel, what kind of birth defect is spina bifida?
It's spinal in nature, Your Honor. It causes a bulbous cyst-like thing to form at the bottom of a spine. And so, Your Honor, as reflected on page 3 of the record, Mr. Benjamin Pierce was an Agent Orange exposed Vietnam veteran who participated in a fertility study from 1978 to 1979. This group of claimants allege they are the offspring of Mr. Pierce as a result of that study. Now, as indicated,
Mr. Correa, well, you had said assume parental responsibility in your opening, and I'm assuming you were referring to 38 CFR 3.210B.
yes, Your Honor.
So, before we get to the regulation, what statutory authority is there for imposing a requirement of assuming a parental responsibility?
If we were to look at the controlling definition of child under the statutory benefit scheme enacted by Congress so 38 U.S.C. Section 101. If we were to look at the types of evidence Congress thought would establish one as a child for VA benefits purposes, they would require a judicial decree stating one is a child, or an acknowledgement by a veteran. And so in statute, likewise, in regulation, VA's stance here is supported, Your Honors. And turning to my first point.
But could I to stick on that? So it is true that Section 101(4), I think, defines child, as you're saying. But for spina bifida benefits, or benefits under subchapters 1 and 2 here of this particular part of 38 U.S.C., in 1831, so 38 U.S.C. 1831, it says that in this chapter the term child means, okay, and then it goes on, and instead of just using the term child, which would then divert you back to 101, it actually uses a modifier. It uses natural child. So the word natural must do something, because it must do something to child, because otherwise you could just refer to child as the definition in 101(4). So doesn't the notion of natural really lend credence to the respondent's point that really it is a biological relationship that Congress was concerned with?
Your Honor, I would disagree that the term natural leads credence to the respondent's point here, mainly for the fact that natural child would be contemplated under subsection A of 3.210 to connote a legitimate child.
Well, why would that be? Couldn't one be an illegitimate natural child? Because then it would seem odd then that if legitimate was meant to be natural, that if Congress used natural to mean legitimate, then why wouldn't VA have used natural instead of legitimate in 3.210? You see what I mean?
Yes, Your Honor. And VA distinguishes between the legitimate and illegitimate child here, I think, because an assumption is required. In the legitimate context, Your Honor, the assumption of parental responsibility is presumed. When one is born of two married parents, there is an implicit assumption of responsibility in that relationship. But in the illegitimate context, it requires an opting in on the part of the father to show a connection. And if we look at the requirements under the regulation here, it would imply, the regulation being 3.210 here, it would imply that the secretary requires an assumption. In the illegitimate child context, Your Honors, a father would have to opt in to a birth certificate at the moment of birth to actually get his name there. And
Counsel, didn't the father opt in this situation?
No, Your Honor, he did not.
Wouldn't the participation in the Harvard study indicate an implicit, if not explicit, opt-in by the father, knowing that his sperm would be used?
No, the record is unclear as to what Mr. Pierce knew he was getting into in the entirety. He knew he was donating sperm in the study. It's not any indication he knew that he would be responsible for any sort of benefits that would flow to the children from his donated.
Well, is that necessary for him to opt in? I mean, if he actually agreed to the study and he knew his sperm would be used for some purposes, isn't that an implicit or explicit opt-in?
Your Honor, I would say for VA benefits purposes, the opting in of an assumption makes sense for two reasons. First, it would ensure that in the dependency and indemnity benefits context.
My question is, why isn't that an opt-in?
Your Honor, it wouldn't be an opt-in because he wouldn't know how many children he was fathering.
Does that matter?
I think it does, Your Honor. It matters because even in a state court setting, or rather in ordinary sperm donation settings, individuals are not responsible for the children that are the result of them being sperm donors. They are the responsibility of the couples with conception issues that receive sperm in.
Wouldn't we want, I mean, why wouldn't we assume that, because really the whole idea is you answered the Chief Justice's question about the nature of spina bifida, right? It's a serious medical condition. And it's a serious medical condition that is experienced, in this case, by the children. And it's experienced by the children because their parent served the nation. So why would we assume that the Department of Veterans Affairs and Congress would tie providing a benefit to somebody who has a defect because of somebody else's service? Why would we tie that to that person saying, yes, I want them to get the benefit, right? It's not like educational benefits or home loan benefits or something. This is a physical condition. Why wouldn't we then say that if we have any doubt, we should do it in favor of the respondent?
Your Honor, I think this scheme is different in some ways from the other benefits schemes that Congress has enacted. However, requiring an assumption in this context assures that a claimant is sufficiently tied to the veteran. VA and the federal government have a finite pool of resources that are available for claimants that are.
But why would they have to be sufficiently tied? That might go to your second point, right, which is whether or not the evidence here is sufficient to establish a biological relationship, right? But let's just assume that there was 100% certainty that a child was biologically the child of a male veteran who served in Vietnam. What logical sense does it to say that one child will get a benefit for their serious medical condition, the other child won't, and it all depends on the fickleness of whether the father decides to say, yes, that's my child? I mean, what rational basis would there be behind that? Not in the constitutional sense, but in a common sense.
Your Honor, I think the rational basis is that is found in the finite pool. I mean, there are people who have enough evidence who can show that they live with the veteran, that the veteran took care of them, and requiring only a biological showing in this context would harm those other claimants. But Your Honor, turning to my second point, that if biology alone would confer these benefits, Mr. O'Reilly's evidence is insufficient. Here's what we have, Your Honor.
Does the Secretary have clear regulations regarding the use of DNA with respect to biological determinations? Are there clear regulations on that from the Secretary?
Your Honor, internal VA adjudication manuals allow for the use of DNA evidence. So, yes, Your Honor.
Okay.
And
with respect to spina bifida?
Your Honor, it's my understanding it's general in nature and would apply to all claims equally. So, perhaps. So, yes.
So you're not challenging on your second point, right? Assuming you lose on the first point that biology alone can be enough. We're on the second point, and your insufficiency of the evidence point is not tied to the fact that we're talking about DNA evidence, right? So you would accept that DNA evidence in certain circumstances could satisfy it, and your point is this just doesn't?
Yes, Your Honor. It is too far attenuated. What the respondents are lacking here in their interpretation is the key ingredient, and that is a direct biological tie to the veteran. Here's what we have. We have a 23andMe DNA profile report chart on page 43. It's not incredibly scientific. It states percentages. We have a lay statement on page 44 from the purported uncle, Mr. B.J. Pierce. We have a mother's lay statement on page 46, and we got the service records on 49 to 53. At most, Your Honors, what the respondents have here is an inference of a biological relationship between the veteran and the claimants here.
Could you remind me, I should know this, but I'm forgetting. So way back in our process at the Board of Veterans' Appeals, did the board rule against the respondents based on what I'm going to characterize as your first argument? Or did it then go on to also assess the adequacy of the evidence?
The board's denial of claims here, Your Honor, was rather vague, and that's because there was neither a showing of the assumption, nor was there a showing of a biological relationship, merely an inference of that relationship. There's no evidence in the record. The record is silent as to the purported uncle here being biologically linked to Mr. Benjamin Pierce, and Mr. O'Reilly could have presented more evidence at the board level of that relationship. We see VA on page 36 of the record. VA asked for more evidence, and we can see on page 44 of the record the uncle stated there was additional family members still living who could testify as to the biological link between Mr. B.J. Pierce and Mr. Benjamin Pierce here. And so there really is a lack of sufficient evidence under any interpretation of.
So if VA accepts DNA evidence, is your point that the 23andMe methodology here is not sound or sufficiently persuasive? Is there another test that VA should have recommended that they would accept, or that they should have recommended that the respondent undergo?
Your Honor, there seems to be the 23andMe results are somewhat lacking in sufficiency. However, just because it's a third party makes it no less probative. But it does not directly connect the claimants here.
But doesn't the regulation talk about that the secondary evidence will be sufficient if it reasonably supports a finding of paternity? I mean, reasonably support doesn't seem to be a super high test to me. How are you interpreting reasonably support?
I think by the plain meaning, Your Honor, it is not a high bar, but the respondents here still have not met that because they're lacking that actual connection to the veteran here. And so if we take a step back here, because this...
Could I interrupt you for just 1 second? And I know you might go over, but just 1 second. Are you familiar with the Veterans Court's case a case called SCORE? It's actually, you might think of it as SCAR, but it is Mr. SCORE. That case in one of its iterations held that the board doesn't have scientific knowledge, and just like it doesn't have the ability to use medical knowledge. Would the assessment, to follow up on Justice Bartley's question, the assessment of the adequacy of 23andMe as a DNA test, would that require specialized scientific evidence that the board should have obtained evidence for?
Your Honor, it'd be preferable to have expert testimony as to the DNA. This was a mere chart of 23andMe.
And your recommendation of expert testimony, is that in VA's policy about DNA evidence, or is that your own addition?
Your Honor, it's my understanding it's in the manual. And so for these reasons, we ask this court to reverse the federal circuit.
I have another question, counsel. What would be sufficient evidence, DNA evidence?
Were this court to adopt Mr. O'Reilly's interpretation, perhaps a birth record tying Mr. B.J. Pierce as having the same biological parents as Mr. Benjamin Pierce, or additional lay statements stating that the two were biologically related, Your Honor.
Okay. Anything else, ma'am? Okay. Thank you, counsel.
May it please the court. My name is Seth Toops, and I also represent the petitioner, the Secretary of the Department of Veterans Affairs. The Federal Circuit overruled the CAVC and held that a class action is the proper vehicle to adjudicate respondents' claim. I will discuss why the Federal Circuit was incorrect when it certified this class, and its decision should be reversed for 2 reasons. First, respondent's claim does not satisfy any of the superiority factors. And second, a precedential decision best serves the interests of justice.
Even with 1,000 potential claimants out there, or more than that?
Yes, Your Honor, it does. And we know because the record is silent on where that number is coming from. That was hypothesized at the Federal Circuit level on page 7 of the record, but the record is silent everywhere else as to that.
And we've got, well, a couple of questions on that. We're really referencing numerosity now, right?
Yes,
okay. So, first of all, there are 20 members of this group here right now, right?
Yes, Your Honor.
And, you know, there's no hard and fast number under the rules of civil procedure, but, you know, 20 has been certified as a class, right?
Yes, Your Honor.
And doesn't numerosity make even less difference in what the equivalent of a B2 class?
Yes, Your Honor, that's correct. And actually, page 12 of the record shows that the Secretary has conceded that the prerequisites under 23 have been met. So the only thing that's at issue today is whether the respondents have rebutted the presumption in the CAVC that exists against class actions by showing that a class action is superior to the other available methods to adjudicate. And it's petitioner's contention that they have not. And for the CAVC, class actions are the exception. They're not the rule, and that's because of the court's limited fact-finding ability and its unique appellate national jurisdiction. So ordinarily, the binding precedential decisions are adequate, and that's why the presumption exists. And to make out that exception, then the court outlined a 4-factor balancing test in Score versus Wilkie. And this brings me to my first point, that the respondent's claim does not satisfy any of the superiority factors. The factors can be found on page 7 of the record, but as the Federal Circuit demonstrated on page 8 of the record, the only factor that militated heavily in favor of class certification was that 4th factor from Score, whether the respondents have alleged sufficient facts suggesting a need for prompt remedial enforcement. With all due respect to the claimants here, and while spina bifida is a legitimate concern, the crux of VA is that everyone seeking benefits has issues. And the court's precedent has demonstrated that that alone does not suffice for benefits because in Bowling versus McDonough, for example, the court there in dictum discussed that the class would not have been certified primarily because the 4th factor was not met, even though the claimants were all suffering from severe mental health issues. In Ward versus Wilkie, the class there was not certified, even though the claimants were all suffering from severe physical injuries resulting from their active military service. So although these claimants do have a birth defect, there's enough precedent from the CAVC who did get this correct that doesn't automatically then trigger the need for a class action. Additionally,
but the Federal Circuit didn't rely only on this, I think what they called the unique neurogenetic circumstances here. Didn't they rely on the number of potential claimants out there and the unique circumstances of this case?
Yes, Your Honor, that was a heavy factor that the court discussed. However, page 3 of the record shows that no one is alive who administered this Harvard Medical insemination study, and no records exist from it. All of the classes before the court that have been certified, the classes have been relatively ascertainable, or like the people who would be in the class were relatively identifiable. For example, in Beaudet, the claimants there had all been denied benefits or their applications for the caregiver program before VA, and the class there was then certified because the secretary was in a unique position to notify all of those claimants. And similarly in Wolf versus McDonough, all of the claimants were readily identifiable, or at least they could be readily identifiable.
So what about, so in Beaudet, my reading of that case is that the real linchpin for the reason for certification in that class was the secretary was unable or unwilling to commit to provide notice of the change in law, if you will, the ability to appeal, to people whose claims had already been denied. And so the court determined to certify a class so that those people could be brought in. what is the Secretary's position about people who have been denied benefits for spina bifida because they were purported to be the biological father of, or the child of a father, and the father had not claimed parental responsibility?
Your Honor, the petitioner's contention in that respect would be that if the court decides on this issue, on the first issue, that biology is enough, and the evidence that is here before the court is enough, then the claimants should be entitled to what they deserve. However, a class here is still, there's difficult manageability concerns, and that's why this class is significantly different. Even if the court would like the Secretary to notify or work with the claim or with Mr. O'Reilly for notification, there are other alternatives, but that presumption exists, then they have to show, the respondents have to show that to warrant the need for that slow judicial device that's still in its infancy before the CAVC.
You mean the class certification process? Or
The vehicle, the class vehicle, yes. Because this issue is about the vehicle. It's not about the remedy itself. If the court decides there is a remedy, now this vehicle needs to be discussed because this class is very different from every other class that has been before the CAVC who will be running this class action. The CAVC also discussed in Score versus Wilkie, pertaining to that fourth factor, that age is a heavy factor that can militate in favor of class certification. But the distinction between the Score class, where they were in their 70s and they had been exposed to plutonium dust back in 1966, these claimants are in their early 40s, and yes, they've been living with spina bifida throughout their entire lives, but they just recently found out that there was even an avenue, and spina bifida symptoms show themselves in a variety of ways, and the record is silent on how these particular claimants are suffering from their birth defect. And that should be a significant factor here, as this court established in Bell Atlantic Corporation versus Twombly. A mere formulaic recitation of elements is not enough. And page 19 of the record shows that the facts are too sparse here to suggest that the fourth factor has been met, and this court should find that the fourth factor does not weigh in favor of class certification and reverse the federal circuit.
Now, counsel, you just indicated that this was a fairly unique situation, and Bodette found that the superiority factors were satisfied precisely because of the unique situation in that case. So how are those cases different?
Those cases are different, Your Honor, because the claimants were all identifiable. There was a list of denied applicants who had all demonstrated their due process rights were basically being denied in a way because they did not have a right to appeal, and so they could not utilize the full administrative process.
We have 20 people who are identifiable here, correct?
Yes, Your Honor. And that actually does touch more on the second point, that the precedential decision is in the best interest of justice. Since this class, we do not, or the class as it stands, we do not know who may all be in it because these claimants could be all over the world. So notice in the United States may not be enough, and the Secretary is not in the best position to do that. The precedential decision is going to put in a highway for any claimant like Mr. O'Reilly who shows up 20 years from now and still wants to adjudicate their rights under this, where they would have been a member of this class. And that was the court's main discussion point or fear, was because the court is assuming the risk of prejudicing absent class members. And in every other class, there was less manageability concerns relating to finding the actual veterans who could be prejudiced.
Although, isn't it sort of a one-way ratchet in the sense that the prejudice to class members is most often going to arise when the court rules against a class?
Yes, Your Honor, that's correct.
Right, and as far as I'm aware, the CAVC has never certified a class in a case in which it did not rule in favor of the veteran or claimant, right?
Yes, Your Honor.
So what prejudice could befall the class here should we rule in the veteran, the child's basis in favor? What prejudice would flow?
Your Honor, the prejudice, it's a little too soon to tell, and that's because this record is so sparse. And so every other class action that has been before the CAVC, based on my understanding of it, there were multiple up and down between the appellate's courts and discussing because again, the CAVC is a limited fact-finding ability with limited discovery tools at its disposal. And so because of that, there might still be the potential for prejudice to exist if this goes back down, assuming there's a sufficiency of the evidence issue, and given the fact that there is not a lot of evidence here that is hyper-technical and scientific, and if the court decides that stuff is needed, there's still potential for this to still be continued in litigation. And that's a factor. The manageability issue is a huge issue with this case. And it's short-sighted to argue that a class action is in the best interest of justice when there are so many other tools at the CAVC's disposal that are beneficial for the respondents.
Like what?
Your Honor, from Score versus Wilkie, the court noted the precedential decisions, consolidation of claims, petitions for rulemaking, writs of mandamus.
So what's the difference between consolidating the claims and certifying a class?
Your Honor, certifying the class, there's potential. There would have to be a window open for to find these class members and those kind of things, and then just in the event that the respondents somehow do fail or lose, if this case goes back down, there's the prejudice of the absent class members there, and that's the concern from petitioner's standpoint, because a precedential decision acts like a class action without the prejudice of the absent class members and without the additional stress on the judicial system.
Well, and also without anything other than a very cumbersome means to enforce, right? So one is in a class and the agency acts in violation of the court's order, they can come and seek enforcement at the CAVC. Whereas if it's just a precedential opinion, they have to go through the entire administrative appeal process. Isn't that a distinction?
Your Honor, I see I'm almost out of time. May I briefly answer your question?
I think if it's all right, Chief Judge.
Yes, please.
Your Honor, that is a concern that the court has discussed. However, in Bowling versus McDonough, the court noted that the Wolf versus Wilkie case was an anomaly, and hypothetical noncompliance or the likelihood of mistakes is not enough to rebut the presumption that exists against class actions before the CAVC. And for these reasons, this court should reverse the decision of the Federal Circuit.
Okay. Any questions, May? Good. Thank you, counsel.
Good afternoon, Chief Justice. Please the court. My name is Nancy Erickson, and with my co-counsel, Benjamin Lang, I represent Mr. Walter O'Reilly, the respondent in this case. My co-counsel will address the second issue before this court, why class certification is the superior method here. First, I will discuss why the evidence of record is sufficient to show that Mr. O'Reilly is the biological child of veteran Benjamin Pierce for the purpose of obtaining spina bifida benefits. Your Honors, Mr. O'Reilly respectfully asks this court to affirm the Federal Circuit on the first issue for two reasons. First, because Congress would not want this court to defer to the agency's interpretation of biological child in this case. The regulation itself is unambiguous, and the interpretation is not of a character and context that would indicate Congress would want this court to give it controlling weight.
You're talking about 3.210, counsel, or 814?
Chief Justice, I'm talking about 3.814.
Okay.
And second, because the board erred as a matter of law by failing to apply the benefit of doubt doctrine in Mr. O'Reilly's favor when there was at least an approximate balance of positive and negative evidence. To my first point, petitioner did not explicitly address agency deference, but that's really what we're talking about here. The VA...
So could I go back to the question I asked your friend on the other side, Mr. Creel? the parties are jumping right to the regulation, I understand that, but of course regulations derive from statutes generally. And what do you make of the fact that in discussing the spina bifida portions of this in particular, Congress included the modifier natural before child? What does that mean with respect to the Secretary's position in the regulation, whether it's ambiguous or not? Do you follow me?
Yes, Justice Allen, I do, and I think it means, honestly, just about everything. I mean, we're talking about Congress having a statute that says it wants to compensate the natural children of veterans whose military service exposed them to Agent Orange, and it's because of that exposure to Agent Orange that their child now has a genetic disease. Spina bifida is passed through a purely biological connection, and so it's unambiguous that the regulation we're discussing here, 3.814, when it says the natural child or the biological child of a Vietnam veteran, it's talking about only that purely biological connection. And you know, this court in Brown versus Gardner said that ambiguity is not a creature of definitional possibility, but of statutory context. And so the statutory context is clear here that biological child is talking about a purely biological connection.
So is 210, I'm sorry, go ahead.
Well, when in 3.814, doesn't that regulation incorporate parts of and talk about using the, for lack of a better way to characterize it, standards of proof, the methods of proof that are in 3.210?
It does, Justice Bartley. It says that the same types and proof of evidence that are outlined in 3.210b should show the parental relationship. And 3.210b is an evidentiary regulation that talks about establishing a relationship for a variety of VA benefits. I think even if you look to the statutory context of 3.210b, it's unambiguous that biological child is purely biological. So the underlying statute there is 38 U.S.C. 101, which is completely silent as to proving parentage of a mother, a female veteran. It only talks about the illegitimate child of a father. And the enacting regulation there, which is 3.210b, is even more clear because it says, as to the mother, proof of birth is all that's required. So whether you look at 3.210b or 3.814, it's unambiguous that a purely biological connection is what's being discussed here. And this court said in Kaiser that when there is no genuine ambiguity, Justice Kagan wrote, this court has no business deferring to the agency's interpretation of the regulation, no matter how much the agency insists it makes sense. So no matter how much the VA insists it makes sense to require an assumption of parental responsibility, this court should disregard that and not privilege it above any other litigant in this case, because the term biological child is unambiguous. It should enact 3.814 just as it would any other law.
So to follow up on Justice Bartley's line of questioning there, does 210 go farther than the statute would? Is it more restrictive with the additional requirements of parental acknowledgement and things along those lines?
Well, 210b is a non-exhaustive list that shows the biological relationship between a child of unmarried parents and their father. So the Congress did give the Secretary the ability to establish types and proof of evidence, and so the Secretary is doing that here in Regulation 3.210b. He's promulgating this regulation to further describe a non-exhaustive list of the types and proof of evidence.
But all of the kinds of evidence that 210b talks about reference the veteran accepting the child or acknowledging the child, correct?
Well, Justice Bartley, I think there's two ways to answer that question. So first, this regulation goes back to the 1960s, to a time when it was difficult to establish with scientific certainty a biological connection like we can now with DNA evidence. And so the types of evidence that the Secretary listed, and the majority opinion noted this in McDowell versus Shinseki, the 2009 Veterans Court opinion, that the types of evidence listed in that regulation could just as easily go to show an individual is the biological parent, meaning a purely biological connection, as to show an assumption of parental responsibility. But also, the Secretary has issued guidance in the M21 that says that for the purpose of establishing a parental relationship, DNA evidence may be considered. And so, again, that really gets to the second issue, the second deference piece here, which is the character and context of the agency's interpretation. The interpretation here, it doesn't represent the agency's fair and considered judgment. And it's really not the agency's official position. I mean, we're not seeing this in an official policy statement or guidance that the Secretary is passing down. We're seeing it on page 6 and 11 of the Joint Appendix in the Veterans Court and the Federal Circuit opinion. And this is an interpretation that's it's not born of policy making, it's born of litigation.
And two questions on, we've drifted into Kaiser land here, right? And so, two questions. Number one, is this regulation ambiguous, or is it just silent about DNA? And second, didn't Justice Kagan sort of come pretty close to saying that litigation briefs just don't count for deference purposes?
So, to your first point, this regulation is unambiguous with that purely biological connection. And
well, it is and it isn't, right? I mean, it's not ambiguous in the normal sense of when we think about that, like you can't be too tall, and then okay, it's ambiguous. What does tall mean, right? Here, it's saying that you have to establish this relationship, and it's possible it could be ambiguous in saying, were those just proxies to equivalate to be equal to what it is for the mother, which is proof of birth is it, right? And for fathers, it's different, so we have to come up with something else. But your position seems to be that it's unambiguous, which means we never even get to the Kaiser point, right?
That's correct. If the court finds that it's unambiguous, then there's no need to go through the additional Kaiser steps. The court just enacts it as law and doesn't have to consider, the fair and considered judgment, the reasonableness, the official litigating position. If this court finds that the regulation is ambiguous, though, it still need not defer to the agency in this circumstance because this interpretation doesn't represent the agency's fair and considered judgment. And you had asked me about, I believe, Justice Allen, you asked me about the litigating position second.
Yeah, whether or not there's any circumstance under which, under the new regime after Kaiser, that an agency's fair and considered position could ever be presented in a litigation brief.
It could be. The Kaiser opinion cited Auer, which said that Justice Scalia wrote in Auer that an interpretation coming up for the first time in litigation, in that case it was the Secretary of Labor's interpretation, he said it does meet the Auer standard, and then he said because it clearly reflects the agency's fair and considered judgment. And in Kaiser, Justice Kagan told us what that means. And she said, fair and considered judgment, it's not just a convenient litigating position. It's not just a post hoc rationalization for a decision that was made by the agency. It's not something that presents a surprise to the parties. And the VA in the past, in McDowell, said that pure biological connection is implicit in 3.210b. In 2006, in the Federal Register, the Secretary published notice and comment proposed changes to establish proof of parentage, and he used that term natural child, Justice Allen, which you said gives this notion, it lends credence to the point that natural child is just this purely biological connection. Even as recently as the BVA decision on page 21 of the Joint Appendix, the Board of Veterans' Appeals said that an illegitimate child encompasses a biological relationship. So this doesn't reflect the agency's fair and considered judgment.
So what about the second part of your opposing counsel's argument that the evidence here just isn't good enough? It's too attenuated. So first of all, I have two questions about that, if you could address them in whatever order you want. One, did the board actually rule on the sufficiency of the evidence, and what was its ground? And number two, what's your take on what the sufficiency of the evidence is, regardless of what the board said?
Absolutely, Justice Allen. So the board did say that it found by a preponderance of the evidence that Mr. O'Reilly didn't prove a relationship. But our contention on the second issue is that the board erred as a matter of law in that finding. And that is the case whether the court defers to the agency interpretation or not.
Could I just stop you on that first point? So there's two ways to take what you just said, and I just want to make sure I'm understanding which one. One is that the board determined that the evidence was against the claim, but its underlying rationale was essentially proceeding along the idea that there wasn't evidence of assuming a relationship. Therefore, the evidence is against the claim. But really, that's an interpretation of law of what's going on. The other is that the board could have weighed the 23andMe evidence and the fact that it went to a brother and it didn't go to him and balanced that evidence. That's much more of fact-finding in the right legal realm. Do you see what I mean?
I understand, Justice Allen, but I still think there's an issue of law there, even if you just look at, if you ignore the assumption of parental responsibility and say, let's just look at, the board's decision on the purely biological connection. The Congress in 38 U.S.C. 5107B said, when there's an approximate balance of positive and negative evidence, the Secretary should give the benefit of the doubt to the claimant. And the enacting regulation 3.102 says that's applicable even in the absence of official records. And so whether the standard is preponderance of the evidence or the benefit of the doubt, based on the DNA evidence, the respondent should win the sufficiency of the evidence question as well. So in Schoenfeld v. Apfel, the Seventh Circuit said that a genetic test constitutes clear and satisfactory preponderance of the evidence. But
is a genetic test, and I'm going to ask a question I have absolutely no idea the answer to. So is a genetic test that shows a relationship to my sibling sufficient to show a relationship to me that would satisfy the preponderance of the evidence or benefit of the doubt standard, right? There's a lot of parts to that.
I see your question, Justice Allen, and there is federal case law that has said that a DNA connection with a secondary relative is sufficient to establish parentage. That's Tips versus Metropolitan Life Insurance Company, the Southern District of Texas, 1991, on page 578, where the court said that a genetic connection with a secondary relative is sufficient. And even the VA's own manual, M21, says that when evaluating medical and lay evidence from non-VA sources, the board should accept that evidence at face value unless there's a reason to question its competence.
Counsel, does the TIPS case say solely that secondary evidence, or is it in conjunction with other pieces of evidence?
Well, if it is in conjunction with other pieces of evidence, the respondent has submitted that here with the lay statements.
The mother's statement and the uncle's statement or brother's statement.
Yes, Chief Justice. And that brother's statement not only establishes the biological relationship, but also the assumption of parental responsibility, because he said that his brother told him he has grade A sperm and he helped a lot of people. And so given all the evidence here, the board did err as a matter of law. Chief Justice, I see my time has expired. May I have just one moment?
You may continue, yes.
The board did err as a matter of law by failing to apply the benefit of the doubt when there was at least an approximate balance of positive and negative evidence here.
I think Justice Bartley has
Now, respondents' argument seemed to be that DNA evidence is fine, but the 23andMe results here, I don't know if we'd call them DNA evidence, were somehow more suspect than regular old DNA evidence. Could you address that?
Absolutely, Justice Bartley. So I think the VA does have the policy that I mentioned in the M21 of accepting medical and lay testimony from outside VA sources at face value. But I understand that policy is not necessarily legally binding. I think it's important to take a step back and look at congressional intent here. Congress intended to compensate children who were born with spina bifida because of their parents' service in Vietnam. And the joint appendix tells us that BJ was, on page 16, that BJ was the veteran's only brother. BJ has since passed away. So this 23andMe evidence is all that the board has to consider. And Congress's intent is to compensate Mr. O'Reilly for the spina bifida that he has because of his father's service. And that's what this court should do here in affirming the Federal Circuit's opinion.
And I understand that down below you were given the opportunity to submit further genetic evidence, maybe from an expert or something. Why did you choose not to do that?
So the board did send a respondent a letter on page 36 of the joint appendix is where that is, asking for more information. But actually in that letter, the letter didn't say, this 23andMe DNA isn't enough, please go get a DNA test from your doctor. It said, we received the lay testimony and the DNA evidence. Do you have anything else you wish to submit? For example, a birth certificate, a judicial decree, or a statement by a third party that the veteran accepted you as his child. And since the veteran had already passed away at that point, there was no way for a respondent to provide that information, and it's something of an absurd question to ask for a birth certificate for an individual who is the product of sperm donation but still is suffering from a medical condition caused by his biological father's exposure to Agent Orange.
Okay, thank you, counsel.
Chief Justice, may it please the court. My name is Benjamin Lang, and I represent Respondent Walter O'Reilly. We ask this court to affirm the Federal Circuit's decision for two reasons. One, the factors laid out in score favor superiority to adjudicate this case. And two, a precedential decision is not the superior method of adjudication. This leads to my first issue, Your Honors. Applying the factors laid out in score, class action is the superior method. In Score v. Wilkie, United States Court of Appeals for Veterans Claims 2019, the court laid out factors to determine whether class action and class certification is the superior method of adjudication. And petitioner addressed the fourth score factor. Respondent will address all four of these score factors, as this is a balancing test, Your Honors, and no one factor is more or less important than another. The first factor is whether the challenge is collateral to a claim for benefits. The second, whether litigation of the challenge involves compiling a complex factual record. The third, whether the appellate record is sufficiently developed to permit judicial review of the challenge conduct. And the fourth, whether the potential class has alleged sufficient facts suggesting a need for prompt remedial enforcement. And before I begin the first factor, petitioners referenced the presumption against certification that the Veterans Court holds. And this is true. However, overcoming that presumption requires a preponderance of the evidence, which is 51%. 1% that class action, or that class action is the superior method of adjudicating these claims. The first factor.
Could I ask you on that first factor, because it will help me? You're going to give an argument, but when we say the challenge is collateral to a claim for benefits, so what we need to do then is figure out precisely what the class question is. Okay, I understand the class definition, right? But what is the class definition or the class relief that you want?
Relief, Your Honor?
Yeah, so for example, one thing here could be the equivalent of a declaration that biological evidence, DNA evidence, is sufficient in certain circumstances to establish paternity for the father, right? But you could also want a declaration that says 23andMe is good enough, right? And so does the question about whether that's collateral depend on how specific you want the court to rule in the class setting?
Yes, Justice Allen, I believe it does. But here, the class is seeking ultimately declaratory relief in that they would like this statute and regulation to apply to them and receive these monetary benefits from the...
Well, but that sounds like it's not collateral to the class at all. That sounds like it's an award of benefits. Now, maybe it's 6 of one, half dozen of another, right? There could be a situation where the mere answering of a question, does the whole ball of wax. But here is the question that you're asking the court to provide the class with the right to enforce, okay? Is it that you can prove paternity in ways other than the acceptance of parental responsibility? Or is it that DNA is okay? Or is it that commercial DNA companies like 23andMe are okay, right? I mean, and does it matter for whether it's collateral?
Your Honor, it's that the combination of evidence submitted by respondent is sufficient to prove that they meet the statutory requirement for these benefits. And importantly, this first factor, the focus here is on a policy's application and if the merits of the claim are bound with the agency process here. And in SCORE, the court reasoned that because the claim was not closely bound with the merits, a decision by the court would not constitute interference with the agency process. And here, Your Honors, Mr. O'Reilly's claim is collateral to the one in SCAR, and that this is a challenge to the VA's adherence to an applicable regulation, and a decision would not constitute interference with the agency process. Your Honors, a decision here would do no more than what the agency itself had been called upon by Mr. O'Reilly to do in the first place. And the court in Baudette v. McDonough, United States Court of Appeals for Veterans Claims, they found that almost all cases before the court center on some legal challenges that are collateral to an underlying claim for benefits. So this proposed class meets this first factor, Your Honor. The second factor, whether litigation of the challenge involves complying a complex factual record, Justice Allen asked, isn't the DNA complex for the board to interpret? And the petitioner said, yes, Your Honor, it is, and that's why we should have some expert testimony to help interpret this. Importantly, this is what the factor is looking at, is whether or not this is a complex record, and that should a court issue a presidential decision, it would be hard to interpret that record across the board, and instead it would make more sense to have this class certified so that the court could review this in one fell swoop.
So that goes back to a little bit to the sort of first question I'm asking you, right? Which is, so in SCORE, as I understand SCORE, the issue was in part what you've said, but also in part that the assessment of how you're going to go about figuring out the amount of plutonium or radioactive exposure in Palomares is complex, and the agency might as well do it only once. Right? Why have the agency do it repeatedly? And so what I'm wondering, and this goes to some of Justice Bartley's questions, is this 23andMe assessment like SCORE in terms of its complexity, or is it more like just a garden variety sort of assessment of evidence that a fact finder will do? Do you understand what I'm asking?
Yes, Justice Allen. And it's the response position that this is not a garden variety interpretation, but it is also not as complex as what was being interpreted in SCORE with the varying radiological interpretations. But as the petitioners pointed out here, this would require expert testimony, and this would need, it's a sufficiently complex area of science. And so that's why this would be more efficient to have under one roof, Your Honors. And it's also, this is meant to reserve the class device for challenges that will likely require extensive record development at the agency beyond the class representative's individual claim for benefits. And here the VA would need to provide records to future claimants should the court issue a presidential decision, which would be burdensome to an already backlogged system. The third factor requires that the record be sufficiently complete for adjudication. In SCORE, the court reasoned that the extent to which a proposed class will require additional fact-finding is an important consideration in determining whether the presumption against class action is overcome. In this case, Mr. O'Reilly and the proposed class have no additional evidence or additional records to provide.
So when you say the rest of the class, right, there's sort of two ways one can think of the class here. One is the class is Mr. O'Reilly and his 19 half-siblings. Right, they are clearly aligned, and the development of all evidence is done as to them. But wouldn't it be a significantly different factual record for if we include, as the Federal Circuit seemed to suggest, thousands of people, right? They're all not going to have the same. I mean, they might not even have 23andMe, right? There's probably several types of these DNA companies out there. So what do we do with that?
Yes, Your Honor, and it remains to be seen the specific facts of the additional 1,000 class members that the Federal Circuit referenced in their opinion. But regardless, as we stand today, the proposed class has 20 members, and all records from the study in question have perished, and there are no surviving personnel from this study. And so the court does not require any additional information to hear the case and decide the case on the merits as we stand today.
So basically, it's the class is going to be restricted not to, if I recall correctly, not to everybody who's got DNA evidence in the world, but basically all the people that were fathered, for lack of a better word, through the sort of prolific activities of Benjamin at Harvard Medical School. Is that right?
Yes, Your Honor, as well as any similarly situated potential claimants.
So I'm good. Go ahead.
Well, do we have the 23andMe or other DNA evidence of those others, or do we just have the DNA evidence as to Mr. O'Reilly?
As far as what is contained within the joint appendix, Your Honor, we only have the reports for Mr. O'Reilly and his 19 siblings.
I just wanted to ask a little bit about the main ground that the Federal Circuit used, and the one that seems like the most important to consider, at least in a lot of cases, and that's the fourth one. So why wouldn't a precedential opinion that binds the agency, why wouldn't that be sufficient to provide the legal ammunition, if you will, to the class members?
Justice Allen, a precedential decision in this case would not be the most efficient or consistent means of adjudicating these claims. It would be a monumental waste of judicial resources and the resources of the VA to send these claims back down to be relitigated, as well as any other future potential claims, which again the circuit has pointed out there may be at least 1,000 additional claims. And as well, a presidential decision would have to be interpreted by the regional offices of the VA, and that would open up the door for different interpretation issues, and as well, this court having to ultimately hear more challenges on the same issue.
Well, and so that's the rub, right? So because on the one hand, and I think the CAVC has struggled a little bit with this, right? If you look at it in one way, nothing should be a class action because precedential opinions always bind the agency. But if you look at it slightly differently, everything should be a class action because everybody should be able to enforce, right? And you see a little bit of that tension in the CAVC's decisions between Wolf, for example, and Bowling, and Baudette and Bowling, although they temporarily weren't at the same juncture, so Bowling couldn't comment on that. But why is this case then more like Wolf and Baudette on the one hand than Bowling and Ward on the other?
Well, Justice Allen, as Chief Justice Davis pointed out, this is a fact-specific analysis, and this will vary based on the unique facts of each individual appeal. And the individual facts of this proposed class merit prompt remedial enforcement as to the fourth factor. And the fourth factor demands that proposed class members present a need for prompt remedial enforcement. In Score, the court reasoned that plaintiff's severe disability merited prompt remedial enforcement. And the proposed class presents a similar need as all members have spina bifida, a severe disease. And further, the revised criteria for monetary benefits for individuals born with spina bifida indicates that children born with spina bifida may receive anywhere from $200 to $1,400 a month to help with treatment costs. Proposed class members are all at least 38 years old. The past 38 years amounts to missing out from anywhere from $100,000 to $600,000 in benefits. The Joint Appendix is silent, as petitioners pointed out, to the specific plagues of the disability. However, it's well known within the Joint Appendix that this is a severe genetic disease that has many ramifications.
But don't we have to be wary? So take Wolf, for example, right? The CDC described Wolf as sort of an outlier in some respects, and that was because of at least what the majority in that case thought was a very suspect history of the agency trying to get around some other rules, making the need for enforcement very important. But in the garden variety case, we will assume that the agency will follow the law, right? So why is the need for enforcement here so critical? I understand your point about why it's important for the people to get their benefits quickly, but if you say enforcement, what that really means to me is we don't think the agency will follow what the court says.
Well, Justice Allen, to first address Wolf v. Wilkie, as the court noted there, the class action device would allow for consistent adjudication of similar claims involving the regulation at issue, which is very similar to this, and it would also allow the court to more quickly address the issues and reduce delay associated with individual appeals. And here, Your Honors, it has taken 3 years for this to reach the court, which is relatively fast. However, for the future potential class members, should this court issue a precedential decision, they would have to go through the same process, which would undoubtedly be far longer than 3 years. And so to go back to how this merits prompt remedial enforcement explicitly, to answer your question, Justice Allen, the average lifespan for an individual with this type of spina bifida, as seen from page 9 of the Joint Appendix, is roughly middle age, around 40 years. These class members are all 38 or 39 years of age, and the overarching theme in SCORE for prompt remedial enforcement was that the class members, or the proposed class members at issue, were all towards the end of a lifespan, and that having to run through the VA claims process would be extremely burdensome to the parties. This is identical to the case at hand, in that these potential class members that stand today may not have very much time left to go back down to the VA, as well as future potential class members, and argue back and forth with the VA as to whether or not they meet a precedential decision. Further, Your Honors, moving on to my second issue, I see my time has expired. Chief Justice, may I briefly conclude?
You may, after you may have the opportunity to answer a couple of more questions. Justice Bartley, did you have?
I do have
Okay.
questions, but you can go.
Okay. Mr. Lang, you addressed Justice Allen's question regarding one of the factors in SCORE on whether or not this was collateral to a claim. And I thought you did that very well. So given your response to that question that you asked, if a precedential decision is really only focusing on some of the collateral matters, like 23andMe and the usefulness of that in this context, or Ancestry.com, secondary biological relationships being sufficient or insufficient, however that's addressed, and coupled with lay statements, wouldn't a precedential decision actually lead to a resolution of many of the pending claims in this context?
Chief Justice, that is absolutely possible. But as we stand today, and for the future potential class members, that was cited in the Federal Circuit's opinion, to issue a precedential decision that the regional offices would then have to interpret would amount to heavy adjudication of these identical claims, in that there will be undoubtedly arguments presented as to why a individual claimant either meets or does not meet the precedential decision, which again would work its way up in a VA system already rife with delay and end up likely back before this court.
What about consolidated appeals?
Chief Justice, the petitioners conceded as to joinder of claims being impractical, which is ultimately what consolidation of claims would amount to, a joinder of all the claims before the court today. And as petitioners have already conceded in the lower courts, that would not make sense for the claims at hand.
I guess my question is somewhat similar to Judge Davis's. It seems like there are a number of distinguishing factors for your case as opposed to Bodette, Wolf, Ebanks, and some other cases. And that is, like, you have fewer numbers. They're not, at least right now, you just said your class is composed of the 20. These are not all severe disabilities as the petitioner mentioned spina bifida can be relatively mild, and we don't have evidence, I take it, on whether these are severe cases or mild or a mix. For the 20, do you have any indication of that?
Your Honor, we do know that the type of spina bifida Mr. O'Reilly has is, I probably not pronounce this correctly, monogeniclicide, which is the most severe form of spina bifida.
Meningocella, yeah,
Yes.
Bacilli, yeah. Okay, and regardless, though, there's no like VA delay here that's been pervasive. There's not only kind of underlying VA problem that needs to be fixed by this, other than a disagreement about what kind of evidence suffices for paternity. So there seem to be a lot of these distinguishing factors. As I said, similar to what Judge Davis said, I'm not convinced. So convince me about the class element here.
Your Honor, this court is especially equipped to certify this class. And if I'm doing my best to answer your question, Your Honor. I believe the ultimate answer is that having a presidential decision would be ultimately extremely burdensome to the 20 new members today, and as well the 1,000 additional class members. And the reason, again, is because if this court were to issue a presidential decision under these unique facts, as Justice Bartley pointed out, this would require complex litigation by the regional offices, which they are not ultimately equipped to do necessarily. And so that would lead to inconsistent applications of the presidential decision on, at minimum, these 20 class members as we stand today, but undoubtedly the additional 1,000.
Right, but if we said we agreed with the Federal Circuit and held that indeed 23andMe and similar evidence is fine, then there was a precedent decision that applied to anyone down below. I don't know how this would be a very time-consuming deliberation for each of these 20 people. It certainly wouldn't be any more time-consuming than for the thousands of other spina bifida claimants that there are in the process, in process. Their claims are in process right now about whether they get a monetary benefit, whether they get health care, et cetera. So I'm not sure, how are these people different? If we made a precedent decision about the DNA, how would these people be differently positioned, or would their cases be more difficult to decide than, as I said, the other children of Vietnam veterans?
Well, Your Honor, we don't have these specifically tailored facts of those additional 1,000 potential class members. So we don't know exactly where they would fall in the interpretation of a presidential decision. But for the 20 individuals today, that would lead to them potentially being granted the benefits that they are seeking. But again, that would have to be interpreted by the regional offices. And while that may potentially work for the 20 today, there surely would be discrepancies with those 1,000 additional class members that are out there. And as I referenced, we don't have the exactly tailored facts as to how they would meet, if they have 23andMe statements, if they have any lay statements, how things would fall for those potential class members. And so we're trying to look at the potential class as a whole and what problems would arise with the presidential decision.
Thank you.
Counsel, it seems to me that a presidential decision could make this whole process a lot easier, actually. Because if, in fact, this is collateral, which I think you persuaded me that it may very well be, then these key issues would resolve a lot of the issues that the 20 potential class members have here, and likely those out there that we're not sure about. I mean, I'm speculating a bit, but certainly there's settlement leads to, this kind of a decision would lead to settlement of some of those cases, it seems to me. So I'm not sure I'm persuaded that...
Chief Justice, the presidential decision on this issue would not only require repeated adjudications of the same issues, but also require absent class members to bring and litigate complex claims individually. And alternatively, a class action plaintiff is not required to do anything. An absent class action plaintiff is not required to do anything. He or she may sit back and allow litigation to run its course, content in knowing that there are safeguards provided for their protection.
Okay. Okay. Thank you, counsel.
Thank you.
Petitioners, I understand you reserved 2 minutes. Is that correct?
Yes, Your Honor.
Okay.
May it please the court, 2 points on rebuttal. First, the fact that the respondents rely upon Section 3814 for their interpretation of 3210 demonstrates the regulation's ambiguity, and therefore the Secretary's reasonable interpretation should be awarded deference. And secondly, respondent contended that the record listed enough evidence relating to lifespan of the claimants and the possibility of numbers. However, the record is silent on the first matter, and the second matter is not supported by any other evidence within the record. There is a manageability concern, and the precedential decision will have the same effect as a class action without the prejudice on absent class members and the additional stress on the judicial system. For these reasons, the court should reverse the decision of the Federal Circuit.
Thank you, counsel. The case will be submitted, and we will return shortly.
All right. Court is in recess.
Good job.
Reach Committee, which includes doing the moot court, as well as our travel oral arguments. I just want to, number one, reiterate what Chief Judge Davis said, which is the partnership with GW has been fantastic. Number two, I want to thank all of the court staff who came in today, the U.S. Marshals, June, Allison, Dawn. I want to thank the semifinal round panels. One of them, my panelists, one of them flew in from Providence for this. The other is a very senior VA official, and then, of course, our clerk of court. And then I particularly most want to thank Dan DeLucia and my law clerk, Mavic Francisco, and my judicial assistant, Kia Hill, who've put in a lot of effort on this, including all day today. They've really done a fantastic job.
Thank you, judges. I'm going to stand right here because I think that's where our camera is.
That's fine.
Thank you all. Welcome again, and thanks for coming out today. I'm going to echo what the judges have already said and what Dean Johnson said, and thank everyone for their volunteering to make this happen. Thanks to the court for sponsoring and for GW Law School again for being co-sponsors on this event. I'd like to recognize Dean David Johnson and Nick Moya and Lucy Hendricks in the back again. They're the student liaisons, and they did all of this work to make this happen up to this point, so thank you so much. I'd also like to thank the Consortium Pro Bono Program. They're our trophy sponsors for a number of years, so thank you again for that. I also want to thank all of our judges. We had a very distinguished panel on the semifinals and obviously on the finals. Like I said, I'd like to thank Greg Block, clerk of court, Mary Flynn, VA's chief counsel for the court litigation group, and Jenna Zelmer, managing attorney from Chisholm Patrick and the Courts Association, Bar Association president. So thank you all, and thank you to Judge Bartley, Judge Davis, Judge Allen. Thank you so much for helping us do the job. It was great, and I'm sure all the competitors really enjoyed having you here and getting your insights. I'd also like to do one more round of thanks because an event like this doesn't come together without a lot of people participating. And that is, the first round I want to thank Mavic Francisco, who's my co-director here. I think she's in the back somewhere. Mavic, you want to stand up? Mavic was the head of the problem development committee, along with a bunch of clerks from the court's editors, and some private bar attorneys. So if you have any questions or problems with the problem,
I thought you wrote half of it.
I know to demur. So I also want to thank the court volunteers, the day of staff here, especially Dawn, okay? June Gumayuga.
Is he there?
Rosie Garza. Allison Ventures, our photographer. Mika Brantley, who's behind the camera somewhere right now, our IT whiz. Kia Hill. And Alex Francis, if she's here. To all of our marshals.
Yes. Thank you.
I'm going to now turn it over to the awards section. And so, Dean Johnson, you want to come up, or are you good there?
I'm good. I'm good here. I just went down and take some pictures. I know you have an official time.
Okay. So we are going to start with, some of these awards have already been announced, and I'm just going to recap them for the record here for everyone. These are the ones that have been announced are for the competitors who are not in attendance today. So I'm going to run through those quickly. The first award was for Best Oral Advocate, and this was based on the preliminary rounds, so that's Saturday at GW. The winner of the Best Oral Advocate was Alexandra Adams from New York Law School. And then we had a tie for second in the category between Brianna Kalagi of the University of California Hastings College of Law and Devin Potts of Widener University, Delaware Law School. We also had an award for the Best Respondents Brief. And our winners for that award were Gavin O'Brien and Jose Pablo Salas from South Texas College of Law, Houston. And again, we had a tie for second place in that category for Brianna Kalagi and Aaron Lau from the University of California Hastings College of Law, and Kelly Baker and Marcia Seidel from the University of Illinois Chicago School of Law. So congratulations again to all of our previously announced winners. And I think Dean Johnson wants me to mention that if you're watching, please send him your addresses. Right, now we're going to do the awards for editors in attendance today. So I want to first invite up Samantha Higgs. She's the consortium's Deputy Director of Litigation to help me present the awards.
And I'm proud TW alum.
Thank you. Okay, I'll keep this very brief. I just wanted to say thank you to all the competitors. I'm from the Veterans Consortium here today to help give out the awards. We are the trophy sponsor and have proudly done it for the past 6 years. It's just wonderful to see all of you guys in person. I'm glad you had the opportunity to do that. I really enjoyed getting to watch your work today. You're all so talented, regardless of what comes out of his mouth next. You have a lot to be proud for. And thank you to Justice Allen, because I was saying SCAR, so I really appreciate that note. And now I've learned something today as well.
And I just want to echo the same sentiments that you all have been hearing over and over again. I've been involved in this competition, albeit in a different role for many years now, and I'm really impressed by this group of competitors today. So well done to everyone here.
And I would just note, Dan judged the quarterfinals, and Samantha judged some of the preliminary rounds. So thank you for doing that.
Let's do the awards. All right, we're going to start with the best petitioner's brief, and I'm going to announce the winners right now. Awards out to the best petitioner's briefs. And our winners of the best petitioner's brief are Catherine Pence and Elisa Simons, University of Wisconsin. Hold on 1 second. All right, 1, 2, 3. Yeah. And the runners-up for the best petitioner's brief are also here, and that's Nancy Erickson and Benjamin Lang from Stetson College.
Thank you. Thanks. Good job.
All right, and now we're on to the awards for the best team and the runners-up for the best team. So without further ado, I'd like to introduce the winners of this year's competition, Nancy Erickson, Benjamin Lang. I'd also like to present these plaques to the runners-up. You guys did an amazing job. It was a very close competition, and you should be very proud of yourselves. So, Reed Carrillo, South Texas College of Law, Houston, and Seth Teese. There you go. Congratulations.
concludes our event for today. Congratulations to everyone. Thank you for participating. Thank you to our volunteers. And another year in the books. Thank you so much. And we look forward to taking it.